Well, good morning, everyone. I think we will go ahead and start the next panel as everyone makes their way in with coffee. My name is Laura DeNardis, and it's a pleasure to welcome you to this panel on the future of global security challenges and digital data. The formal title of this panel is Intelligence Gathering, Encryption, and Sharing in a World of ISIS. So nothing controversial in that combination at all. The premise of this panel really is that the internet is at a crossroads because of the challenges of massive digital data stores. There's a tension between a free and open internet and a safe and secure internet. That's one of the great pressing public policy issues of our time, which is why we are addressing it in this panel with these experts. Think about the economic contribution of the internet measured in multiple trillions per year, and this is projected to increase with the Internet of Things. Now, in addition to economic benefits, the world relies on the infrastructure of the internet in vastly increased ways. Every industry sector now relies on the internet. We like to call it the infrastructure of all other infrastructures. We need it for the capacity for connecting that next half of the world that was talked about in the previous panel. And of course, it's an infrastructure that is necessary for the routine day-to-day interactions of life. So at the same time as the importance of the internet is rising, we have a loss of trust in the internet due to a number of different things. High-profile data breaches, increasing public awareness of massive government surveillance around the world, an increase in illegal practices on the dark web, and a recognition that the same exact infrastructure that has given us global access to knowledge and innovation is also used to empower terrorist organizations like the Islamic State. So that's part of what sets the frame for this panel, just that not only the Islamic State but other terrorist organizations are using the internet to recruit. They're using it to communicate with each other. And of course, there's always the concern about the types of attacks that can occur on critical internet infrastructure. So these are very, very real concerns and heightened only by the spate of terrorist attacks around the world in recent years. So this is a nexus between terrorism, intelligence gathering, and new digital technologies and the types of massive digital data stores that underlie all of this. So there's a lot of contention there between intelligence and private companies over access to data, over the degree of robustness in encryption products. We're all aware of those kinds of controversies. So it's really a great question of our time. What are the limits to intelligence gathering in this environment, in particular in democracies? So lots of complications there. What we've done is we've assembled a stellar panel to address some of these issues. What we'll do is we'll have all of our panelists make remarks, brief remarks, and then we'll introduce a few questions and then open it up to the audience for questions and discussion. I do want to introduce my colleagues. On my left is Sir David Omand. He's a visiting professor in the War Studies Department at King's College London. He's also an author of the book Securing the State, and he has a very long and distinguished career. I call him James Bond on some of the panels that we've been on because he was the director of GCHQ, the United Kingdom's Signals, Intelligence, and Cybersecurity Organization, and he was also the UK's first security and intelligence coordinator. We're delighted to have him. On his left is Alan Butler from my home city of Washington, D.C. He's a senior counsel at the Electronic Privacy Information Center, and in that capacity, he manages EPIC's appellate litigation, including the amicus program. He files briefs. He's written a number of briefs on national security, open government, and privacy issues, and has published in many law journals as well. And at Columbia and beyond Columbia, a professor who needs no introduction is Steve Bellovin, professor of computer science. He does research on networks, security, and public policy issues. He was with Bell Labs for many years, and the bio is too long to read, but some of my favorites. He served as the chief technologist of the Federal Trade Commission, and he's a member of the National Academy of Engineering and has been inducted into the Cybersecurity Hall of Fame. He also is an author who wrote Firewalls and Internet Security, Repelling the Wily Hacker. So with those introductions, I think I will turn it over to Sir David Omand, and then we will sequentially hear from our other speakers.
Well, thank you very much for the introduction, and good morning, everyone. When the Dean contacted me and she said, come over for this conference, I couldn't resist. I've even produced an issues paper. There should be copies on the table, and I look forward to discussing some of the suggestions that I've put in that for the norms which should govern the behavior of democratic states when it comes to intelligence gathering, encryption, and the other issues. It struck me when I was listening to the fascinating discussion we've just had that one of the messages from Arati was, we're just at the beginning of a revolution in human affairs. The combination of artificial intelligence, big data, internet connectivity, and the Internet of Things to come. But it was also very clear to me that we have now very decisively passed the inflection point. We are now completely dependent on this internet infrastructure for economic and social progress, to deliver international economic development, and for our national security and public safety. We all know the issues around trust in an open internet as a safe place to innovate, to do business, to trade, to interact socially. In terms of my remarks, though, I want to emphasize another aspect of trust. Trust in the ability of the authorities to uphold the law in cyberspace. And that trust cannot be taken for granted. If I can offer you a perspective from the United Kingdom, looking back, the second half of 2013 and most of 2014 were years of, I would describe as digital revelation. The material leaked by Edward Snowden simply woke the public up to something they had not realized, which was the power of digital intelligence gathering. To get information from mobile devices, from networks, from databases, in ways that people simply hadn't realized would be possible. This triggered what I would describe as a European moral panic over privacy, issues around mass surveillance, campaigners launched a string of legal cases. We had European Court of Justice decisions, important decisions over issues such as digital harbour and so on. And this very lively debate also generated considerable public concern, I think I would say, over the privacy implications of the business model of the internet, which most people simply had not thought about. The service was free at the point of use. The fact that it was paid for by the monetization of our personal data was not something that people had really thought about. So that was sort of 2014's revelation. In contrast, 2015 in Europe, I would describe as a year of threat recognition. Tragic attack, the Charlie Hebdo attack in Paris, attack in Copenhagen, Brussels attack most recently, Paris attack at the end of last year, the events in Syria, the interventions of Russia, a string of events which helped swing public opinion back to recognize the legitimate need for government to actually gather intelligence on which decisions about national security can be made. The dictators, the terrorists, the child abusers, the cyber criminals, human traffickers, proliferators, people who were exploiting this wonderful digital space to do us harm. The 2016, I would characterize the year we're in now as a year potentially of digital reconciliation, when mature democracies have got to sit down and work out how are we going to reconcile the gathering and assessment of the information needed to keep us safe from the kinds of people I've just mentioned, with our rights, for example, to privacy. It's a double security, in a sense, we're looking for: the security of people and persons, and the security for our data and our personal information. In the UK, I've been giving a lot of talks saying, don't try and have a calculus of trading security for privacy. You need both. If you don't have security, you certainly won't have rights upheld. But you need privacy. You cannot simply optimize on security. One way of trying to model this is to think about three levels of activity. At the top level, we have our daily life, the interactions we have on the web and on the internet, the trading, the economic use of the internet. We have to take, I think, very seriously the concerns individuals have expressed for their right to privacy, for the protection of their personal information from hackers, from carelessness on the part of corporations, from unrestrained government surveillance, come to think of it, from new techniques such as predictive analytics, and indeed this very business model of the internet. When you look at the priorities that should apply at that top level, given our social and economic dependence on the internet, certainly in the United Kingdom now, it is accepted that strong encryption is essential. You cannot have an insecure internet if we are going to derive its benefit. Nor can you have the fragmentation of the internet if governments seek to restrict where their citizens' data is actually going to be held because of those fears. But there's another level below that, which is where law enforcement is trying to deal with the worst excesses of criminality on the web. This is where senior law enforcement professionals have expressed concern over the way that criminals can exploit the vulnerabilities of the technology, and indeed, I might add, human behavior when they're using that technology. As we just had mentioned, the way that the terrorists of Daesh have been able to use the web to publicize their atrocities and recruit new followers. The sad truth is that law enforcement is finding it extraordinarily hard to police the internet. It's finding it difficult to counter these threats, to establish the identities of the people concerned, and indeed to secure the evidence to bring criminals to justice. One of the things law enforcement has therefore been doing is looking at this third level below of activity, where national intelligence agencies operate, and seeking the help of the professionals in digital intelligence. Their job is national security, the fundamental duty of government, generating intelligence to support military operations, to support diplomacy. And certainly in the United Kingdom and here in the United States, the intelligence agencies have been trying to use their capabilities to help law enforcement. What has been shown over the last few years is that the legal framework for such activity is defective, or in the case of some nations overseas, missing altogether. And the exposure, as I say, of these capabilities has heightened concerns over privacy. As with all hard public policy issues, there is no way of optimizing on any one of these three levels. If you simply say, as some of the privacy zealots would do, hard encryption is everything, then you give free rein to the criminals and the terrorists. If you optimize, as some in law enforcement might, and say, well, we're going to have backdoors built in so that we can access whenever we want to, the weaknesses this will introduce will be, I think, of significant concern. If we simply allow the national intelligence agencies free range and they go and get whatever you like, whenever you like, wherever you like, then the resulting loss of confidence around the world will actually undermine the internet, the use of the internet itself. So it's a satisficing problem. It's a problem where we have to balance the considerations. And in the issues paper, I've tried to suggest a few of the norms that we might discuss, which would help arrive at that. It's a lively debate in the United Kingdom. We have major new legislation in front of Parliament at the moment, which will, for the very first time in 500 years of struggling with these problems, bring all of the modern intelligence gathering under the rule of law. So I hope, I'm happy to discuss that, we might be able to provide a bit of a model there for how a mature democracy can actually provide reassurance. What I think 2015 showed with its sad list of terrorist attacks and cyber attacks is that these digital tools are necessary. And the public debate has shifted from one of sort of outrage and horror that it is possible to do this, through to, well, if you're going to have these tools as a democracy, we want strong oversight, we want independent oversight, we want proper laws. We have to control these tools so they cannot ever be misused. Provided we do that, then I think I remain an optimist.
Thank you very much. Let me ask a quick follow-up before we move along. You mentioned quite a few things: the need for strong encryption, the importance of not taking measures that fragment the internet. You talk a lot in your work about the importance of intelligence gathering practices that are based on principles such as necessity and proportionality. And you also mentioned today the importance of not building backdoors into technologies that would weaken the security and the stability of the internet. But what I want to ask you about is how, if at all, you would recommend extending any of these norms to the private sector, which you mentioned earlier as being the reason that so much data, the business models of the internet really is the reason that so much data is available. Information intermediaries that gather, aggregate, and share data based on online advertising models. So I was just wondering if you have any thoughts about the private sector and whether possible limitations or norms or voluntary concessions that would be comparable to some of the norms that you've provided in intelligence gathering.
Well, let me thank you for the question. Very briefly, just mention 2 points. The first is that, as with the need for law enforcement, I'm not suggesting the business model of the internet can be changed, at least not in the foreseeable future. So we are going to have to live in a world in which personal data has value, and therefore people will, as it were, extract rent from that, they will use it. So it follows that if that is the world we're in, then we have to find socially ways of placing duties on the private sector to safeguard that information. And we've already seen in the last 12 months some major cyber attacks on corporations which have demonstrated that the necessary level of protection of personal data is not yet there. So there has to be some form of liability for carelessness with our data. That's one of the central ideas running through the European Data Protection Regulation, which will come into force in 2018, which is capable of imposing fines of up to 4% of global turnover on companies, including American companies, that have European data and are careless with it, in the sort of gross carelessness sense that we've seen in some recent cyber attacks. That's one thing that can be done. The second is the development and encouragement of corporate social responsibility on the part of the corporations. They have to persuade us to use their products. As a result of 2015, there are signs already that some of the big cyber companies are a little concerned that they are not going to be portrayed as the terrorist app of choice, for example. And therefore, they will cooperate with law enforcement, but only on some reasonable conditions. And I'll give you my view of those. The first is that if a government comes to request information from one of those corporations, it must be a legally proper request, and it must have already passed the necessity and proportionality test. Secondly, there mustn't be a clash of law, so that the corporation is itself put in jeopardy because US law does not allow that. We're almost completed a government-to-government agreement between the United States and the United Kingdom to get round this, which will have to go to Congress after the election, but which would remove that for properly formed legal requests. Thirdly, the corporation must apply a reasonableness test. Is this a reasonable request, both technically and in terms of level of effort? There are some things which would be unreasonable to expect corporations to do. And then finally, the request must not put at risk, unreasonable risk, the data of other people. So if you apply that to the Apple argument, in principle, Apple should lose any argument that data in cyberspace has more protection than data in the real world. They have a perfectly reasonable case to argue that if the responding to a request could potentially put at risk lots of other people's, quite innocent people's data, then that needs to be taken into account before a final judgment is made. The FBI, thankfully, seem to have found another way around that particular argument, but the argument is still there, unanswered.
Thank you very much. Let's turn to Alan.
Great. Well, thank you. Thank you for having me here. I wanted to talk about how I see this from a privacy law perspective, and to get back to why. When I look at the why from a privacy law perspective, the goals that we're seeing and the trends. I think the trends right now in law and what's happening related to privacy. What we're looking to do is we're looking to, drawing the themes out of Sir David's remarks here, preserving individual rights, as mentioned in the call, preserving individual and national sovereignty, and preserving the protections that are inherent in the data. So as we're looking at these changes in social structures, and we're looking at these technological changes, we're trying to understand, and courts are struggling with, and legislatures are struggling with, and the body politic is struggling with how to preserve these rights, how to preserve these interests, and how to preserve these protections. And I think it's important to underscore that the threats we're facing are not only traditional national security threats now, but also threats to individual data, threats to individuals and governments through the use of not only physical force, but also the collection and exposure of sensitive records. Data breaches, identity theft, and risks to personal information, I think, are certainly in the US and I think internationally are at the top of the lists for law enforcement and national security officials' concerns worldwide. So we care not only about protecting individuals and countries from external physical attacks, but also from exposure of the most sensitive records, be it your social security numbers, your personal information that cyber criminals may be trying to get at, or credit cards or other information, or even information like that held by the U.S. government that's been compromised that could be used by foreign nationals that are trying to conduct espionage or conduct other forms of attacks. So looking at those three categories of protections of rights, protections of sovereignty, and protections of data, I see three big trends here in both U.S. and international courts and being debated among lawmakers. And those are issues related to transborder data flows, issues related to encryption and security, and the concept of privacy in the digital space as opposed to physical analogies. So in the cross-border area, we're dealing with different legal systems, US, Europe, and otherwise. We're dealing with data that does not inherently recognize, and networks that do not inherently recognize those legal systems. The implications of that, we're dealing with, therefore, jurisdiction, level of substantive protection, and also issues of localization that have already been mentioned. When you think about the jurisdictional issues here, I think a lot of these will ultimately be solved, but we're still in the process of establishing the underlying agreements and the necessary substantive protections to make that work. If you look at the Microsoft case that's happening here in New York, you'll see kind of the forefront of this fight, but it takes place in many other countries as well. So the Microsoft case here is a case where the U.S. government is seeking data that's housed by Microsoft in Ireland. And Microsoft is challenging the jurisdictional basis to order them to turn over that data in a U.S. court. But the flip side of that, of course, is orders in foreign countries for data that's housed in the United States. There have been orders in Brazil, and actually a vice president of Facebook was put in jail temporarily as a result of noncompliance with court orders in Brazil. So dealing with these jurisdictional lines and establishing the underlying agreements that will enable countries to have meaningful legal process regarding personal data, I think is the critical next step. But what it will require is a recognition of proper substantive protections. And I think that this has to be more of a most favored nations system and not a race to the bottom. So it can't simply be that certain countries will come to the table and say, you, whether it's Europe or the US or some other country, have to lower your standards to the level that we recognize. I think it has to be more of a rising tide in terms of the rights, the substantive protections recognized, because otherwise the dynamic will inherently devolve. There will always be countries that want access to certain data, and I think the United States, what they have to reckon with in this Microsoft case is the fact that they can't just have it the way they want it, but expect all other countries to respect U.S. law, to respect our privacy laws. So I think there has to be a recognition when countries come to the table that the standards have to step up rather than just sort of devolve to the lowest common standard. And establishing those substantive protections, I think we have principles to build on both in the U.S. and Europe. So David mentioned the necessary and proportionate standard. In the U.S., we have our Fourth Amendment standards. And I do think we have a lot to build on there in sort of establishing the international language of privacy, establishing that international baseline level of protection. But we have to get there. We have to understand, the countries need to understand that, again, when they're coming to the table, that needs to be the primary goal, to establish that baseline at a high mark and not to reduce it. And I think the countervailing risk of this is localization, is protectionism. That if countries feel that their rights are being diluted, then the reaction is going to be to try to shut off and minimize those flows. And that's going to be hugely costly for both businesses and countries and their citizens. So I think that those are the kind of the factors that have to be considered. And overall, on the substantive rights front, I think key points about any system have to be the transparency of that system, the ability of the citizens to understand what protections apply and how the accountability and oversight mechanisms work. how, for example, in the US, we have our warrant standard, our Title III standard, and how courts play a role in that, and the executive branch plays a role in that. The citizen's ability to know how that works, I think, is critical to the functioning of a system of privacy rights. And also, I think the other big theme that's been identified in the last few years is that there have to be limits on mass surveillance, that individuals will simply not countenance this idea that be it an intelligence agency or some other branch of the government can simply collect everything at the front end and deal with protections later on. So I think Steve I imagine will probably speak to this as well, but just briefly on the point about encryption and security, I agree with what Sir David said, that this is a security and security issue. It's not a privacy versus security issue. And I think when it comes to establishing technological protections for the information that is already out there about each of us, or new information that's being used or collected, I think it's really an issue of the utmost importance that we continue to improve upon those security standards, that we improve standards of encryption and security and not make them weaker, not sort of implement procedures or implement new rules that are going to limit the accessibility of strong encryption to individuals worldwide. And I think in part because we see, I'm saying this in reaction to a current trend we've seen of attempts, whether it's in the FBI Apple case or in laws proposed in Hungary and other countries to control encryption software. But I think at its core, encryption tools are not really able to be controlled by any individual nation, in part because many of them are freely available on the internet. So I think efforts to control encryption in that way are ultimately doomed to fail for that reason. And instead, I think we need to focus on hardening the protections that our countries, various countries have for personal information and for information that cyber criminals and others are trying to access. So finally, just to take it back to the US for a moment, I think that we've seen courts attempt to update and address the existing Fourth Amendment standards as applied to new areas of new technology. And I think what we will have seen and will continue to see there is a breakdown or a disconnect between the traditional sort of physical analogies that were used to develop those principles and the current updated ideas. So one example of this is or two examples of this. One is the recent Supreme Court case, the Riley cell phone case, where the court was struggling with how to apply a traditional standard for searching a person upon arrest to modern technologies, where individuals on their persons may carry devices that have an amount of sensitive personal information that never could have been carried in your pockets. And the court, I think, rightly recognized in that case that we're simply not talking about apples and apples, that when you're talking about digital data, you can't sort of rotely apply physical concepts or rules that were developed in physical concepts to that data. That you have to recognize the fundamental difference in scale and in scope of those records, and that the applicable rights have to therefore recognize that. And that's what the Supreme Court did in Riley when it rejected a traditional Fourth Amendment exception for searches incident to arrest, where the thing that was being searched was a cell phone, and recognized that it's much different than merely patting down an individual or searching the contents of their wallet. And this is true also in the second example, I think, with location data about cell phones. Traditionally, we've applied a rule that differentiates between certain business records stored by third parties and records created or stored by individuals. But when we're talking about all of the data points that catalog our movements throughout the day over many days and many months and many years, I think we're no longer talking about a few lines on a telephone bill or a few lines on a bank ledger. We're talking about something much more fundamental that goes to the freedom of movement and association. And I think courts are currently in the process of reconceptualizing the application of the Fourth Amendment to that type of data. And this is going to happen in the US, it's going to happen abroad, and courts are going to increasingly have to see that as technologies improve, that we can't simply have an eventual elimination of the ability of individuals to control and protect their information, that the legal protections have to step up as the technological sophistication increases as well.
Alan, I actually have a favorite quote from the Riley versus California case, which is really interesting to read. And it was penned by Chief Justice John Roberts, and he said something like, if aliens came down on the planet, they would think that the cell phone was an appendage of human beings.
Right.
And you're very correct in describing how searching a cell phone raises so many more privacy considerations than searching someone's house, for example. When you think about the healthcare records, the personal correspondences, romance records, every imaginable communication and data about an individual, there can be so much there. I want to ask you a follow-up question, though, asking you to become a technological futurist for a moment. We're moving from a world in which the internet mediates communication to a world in which the internet is a control network that is an intermediating device between things. There are already many more things connected than people connected to the internet. So in this world of the Internet of Things, and the Internet of Self, where pacemakers, biometric identification, Fitbit bracelets, healthcare records, as well as the appliances and the cars and other kinds of things are connected, how do you look at that future environment and tie it together with your third point, which is looking at privacy in the digital space as opposed to privacy in the physical space? So when privacy in the digital space is the same as privacy in the physical space because of that connection with all of the devices and the biometric identification and things on our person, what will privacy law challenges look like in that environment?
Sure. I think there's a couple different challenges that we're going to see as related to the growth, as you've discussed, of the Internet of Things. And I think those challenges come about from the increasing, just the raw amount of data that's being collected, the increasing vulnerability of systems and everyday things, because you are taking technologies and systems that are already vulnerable and you're just multiplying them. You're exponentially growing the amount of vulnerable things. I think those two challenges are related, but they kind of present different issues. So the first one is just the sheer volume of data. I think similar to the problem of cell phone location data that's being generated, again, same volume problem, you're going to run into an issue where traditional notions of subpoena power, scope of whether it's warrant searches or subpoenas or what have you, are going to break down when you have such a wealth of information theoretically available or accessible. If that information is being stored, we are already seeing this just with email. And I think email is like one level, and once you have data collected from all these different devices, it's just going to grow exponentially. So there are going to have to be limits, really narrowing limits on the amount of data that can be collected, even with a warrant, I think, in the view of how much is being generated. Because already we're seeing, as I said, we're seeing this problem with emails, where under traditional kind of container physical space notions, you might think, well, I have a search warrant for this thing, and it's your email account. And I'm going to execute that warrant. I'm going to search your email account. But of course, now your email account probably contains, could contain 10 or more years of records, of files. Whereas, in the physical space, there's only so much that you can store even in your attic in tons of boxes. And with the Internet of Things, this is just going to be exponentially larger. So we're going to have to develop systems to limit data searches, to limit data collection in investigations, and then the flip side of that, to protect all that data and to protect all of the things that the Internet of Things grants access to. So on the security side, that increasing collection, that increasing integration of devices requires a heightened degree of technological protection. We're going to have to continue to spend a lot of energy and effort protecting all that stuff because there's just simply more points of access. It's a greater threat surface, and the more personal data is potentially accessible through these devices, the more these devices can be taken over and used to cross purposes. If you think about what's already happening with sort of attacks that involve an outsider, encrypting your data and then essentially holding it hostage. Well, that's even worse if it's, your house or maybe your refrigerator, let alone your pacemaker. I mean, when you think about the degree of severity of the risk, it's scaling up as more and more pieces of our architecture are computerized. So I think that both on this legal protection side and on the technical protection side, it's going to require increased sophistication in terms of the legal protections and the technologies that we use.
Thank you. Let's turn to Steve.
Thank you. It's curious that you both mentioned Riley. I actually have a quote, one of my favorite quotes from Riley in my notes here, where it's referred to, quoting an earlier opinion, noted that cell phones contain, quote, all the privacies of life. There's a tremendous amount of information on there. Before I go on, I would like you to thank your erstwhile colleagues at CESG for being the most authoritative voice to say that forcing people to change passwords regularly is a really bad idea. It is a long overdue recognition by and it's good to hear that by an organization which can help set standards for even much of the commercial sector. So pass on my thanks to them for your contact with them. We're in a different world, and the international dimension makes life a lot harder. There are, we talk about crypto backdoors, and I'll come back to that point, but it turns out that the international process of access to cryptography backdoors, information in general, has gotten tremendously more complicated. It's inherently more complicated. It's made worse by the borderless nature of the internet. You go back just about 200 years, where did the 3-mile limit for territorial waters come from? Well, that was the range of shore-based cannon about 200 years ago, and that's about when the law of the sea came up with this 3-mile limit. What is the equivalent limit on the internet? The 3-millisecond limit? I don't know what it is. Data moves around. I can access data around the world. I don't know where the data I'm accessing is, whether it's a Microsoft data center that happens to be in Ireland when I'm in New York, or maybe the data is going to follow me. The big cloud providers do have data centers all over the world, and if I happen to be in London visiting my daughter, maybe my email account should follow me because latency matters for speed of access. How do you establish what jurisdiction should be when even the developers of these systems can't really predict exactly what they're going to do at any particular time? The big data algorithms on which we're relying, in a sense, they're beyond our control in that we don't really understand what they do. And I don't mean you and I mean the developers. You can look at an output from one of these systems and say, why did it do that? And the answer is, I don't know. I programmed it, but its behavior is dependent on so many other inputs and other usage patterns that I don't know is often the right answer. It's why Google changes its algorithms 500 times a year, as we heard, because they're constantly tweaking to make it better in some metric, but they don't really understand what it's doing either. And you then add to this the different legal standards, different legal systems, different respect for individual human rights. I suspect that the US and the UK could come to a pretty good understanding on access to data in the other country, but because both countries have a long history of respect for the rule of law, notwithstanding the unpleasantness of 240 years ago over some of those issues. But you know what? The legal standards are still quite different between the US and the UK. And the infringements go in both directions. And then you get the attempts for extraterritoriality. Call it France with its assertion of the right to control Google's right to be forgotten around the world and not just within France. Well, okay, France is a democracy too, though again with very different legal standards than the US and the UK. But now we have Turkey with its insistence that no one any place in the world can criticize President Erdogan, the Dutch journalist under arrest for comments that she made while in the Netherlands. How do we understand the borderless nature? If we're talking about cryptography and a government comes to another government and says, here is some encrypted message that we got, here is an encrypted phone, it is a terrorist. Is it a terrorist in the sense that you and I would understand the word? Or in the sense that, say, China or North Korea would understand the word, or Egypt? How do you make this judgment? If someone presents a phone, well, there's a physical object that government has custody of, it's one thing. If someone presents an intercepted message, you don't know where that came from. Was that really a message by a terrorist or a human trafficker? Or was it a message between two business executives within their own country, not the one that's presented the intercept? We also get the blurring of the lines between intelligence and law enforcement. You know, it's actually good in many cases when law enforcement has to work harder. In another Supreme Court case in the last few years, Jones, U.S. v. Jones, Justice Sotomayor noted in her concurrence that one of the real checks on police misbehavior was not the wording of the Fourth Amendment or the actions of a judge, but simply limited resources. They don't have the ability to surveil all things all the time, and that's good. That's one of the real checks against a police state. But intelligence operations are very often about looking at lots and lots of data. And sometimes the data is in the hands of private companies. I'm perfectly happy to have, if it came to surrendering some of my privacy to defend against ISIS or certain other countries, I might be willing to. It's another thing for me to give up my privacy to enable Amazon or Walmart to sell things to me better. And I want to make sure that I don't give up one with the other. With cryptography, it's also a matter of, it's not just security versus privacy, it's security versus security. Cryptography is actually one of the hardest things that we do when it comes to computer security. It's extraordinarily hard to get right. It's extraordinarily hard to use correctly. You know, I am sure many of you in this room saw the movie The Imitation Game. By the way, that movie I best described as impressionism. The overall picture was correct, but most of the details were completely wrong and occasionally invented. But the overall picture was correct. And one of the things that was presented, really happened was incorrectly, is that German soldiers were told to type 3 random letters. Well, XXX. The first 3 letters of a wife or girlfriend's name. ASD on the keyboard. Nice, easy ones. Well, yeah, that really happened. If the Germans there's a good case to be made if the Germans used Enigma as well at the beginning of the war as it did at the end of the war, that Bletchley Park never would have succeeded in cracking a significant proportion of the traffic. They learned, but as long as it was step by step. Cryptography is really, really hard to get right. Even ordinary, well-understood cryptography is very hard to get right. I saw a study that 80% of encryption using Android applications got it wrong. And mind you, they're using cryptography in a very straightforward, ordinary, well-understood sense, and 80% of the apps were still getting it wrong. Imagine what it's going to be like when you're trying to do something sophisticated and different with cryptography. You know, Apple, one of the more sophisticated companies out there, didn't get the iMessage protocol right. Some researchers at Johns Hopkins found that they could read about 1/3 of those messages. Why? Because cryptography is really hard to get right, not at the 30,000 foot level, but when you actually try to get it right on ground level. And when I worry that when we try to add new requirements, we're going to get it even more wrong. Could there be a suitably restricted backdoor for, designed by the most sophisticated people for one particular application and get it correct? Probably from a technical perspective, though there is still all of the process and international aspects that I worry about. But when I see that 80% of the app developers are using standardized encryption incorrectly, I worry that almost nobody else is going to get it right if we try to add all of this. And cryptography on our mobile devices especially is not just a matter of security versus privacy. It's security versus security. People use their phones to log into corporate and government systems. You don't want to give away this access. You used to carry a little token to log in. Today, you use your phone. Why? Because you have your phone with you all the time. Your phone, I joked when they handed me this microphone that I was now walking around with a bug, but in fact, I'm walking around with a bug at all times. It reveals my location. It reveals my voice conversations, my email conversations. And if I'm in a sensitive position, that really matters. We are using our phones, our computers, to control everything. And it's the Internet of Things, it's the Internet of insecure things. And even if I get the security right on, say, my thermostat or my door lock, my phone is going to operate these things. And therefore, my phone needs strong protection. We need software security, that's a separate issue. But when we look at, for example, the TLS, the encryption protocol developed originally for the web or its descendant, so there have been so many flaws found in recent years, both in implementation and the design of the protocol. And some of those protocol flaws have come about because of attempts to weaken cryptography selectively under certain circumstances. So we really have to try to get this right and not give away the security. So what is the answer for both intelligence and law enforcement? The answer is metadata. Now, metadata is incredibly revealing. The boundary between metadata today and content today is much blurrier than it was when the US adopted its current legal distinctions a bit over 35 years ago. In fact, courts and the Justice Department get the boundary wrong. I have some colleagues have a paper coming out shortly that show that the Justice Department's guidance on access to email metadata is just simply wrong as a technical matter. I mean, there's not even any doubt about this. It's not a subtle argument. But even if you get it right, metadata is incredibly revealing. It's revealing from a privacy violating aspect as well, and the big data firms are gathering all of this information as well. But it's so very hard to conceal technically that it might actually be the best answer. Michael Hayden, former director of the CIA and the NSA at different times, deputy director of national intelligence, has talked about how important metadata is to the NSA's work, and to quote him directly, "We kill people based on metadata." Well, I'm not accusing Amazon of Google of doing that, but it is the information retrievable, learnable, discernible by metadata is that high quality that life and death decisions can be and are being made based on it. And it's very hard to protect with cryptography or other mechanisms. And I would suggest that this is a better alternative than weakening the cryptography, which, if used designed, implemented, and used properly, all of which are hard, is very hard to break through.
Thank you very much. I want to give Sir David an opportunity to respond, and while he does that, why don't we cue up the microphone and start getting some questions from the audience.
Well, thank you. I just wanted to pick up that last important point about metadata. and offer you a way through this that the British Parliament is currently examining in the legislation, which is not to use the term metadata, but to define that part of it, which is who called whom, when, where, and how in the internet era. So which server did your device communicate with? But to recognize that anything beyond that, so the full list of all the pages on Google that you accessed, your full browsing history, is equivalent to the content of the communication. So you distinguish between communication data and the full content, including that higher metadata, which Mike Hayden is absolutely right about. That enables us to continue to allow law enforcement to use who called whom, when, and where, and do network analysis on threats such as terrorist threats, but doesn't just allow the police to go roaming into your full browsing history. And that to do that requires a full judicial warrant, senior judge has to sign off, and so on. Over the last 18 months, the British intelligence and security authorities have stopped 7 attacks on the United Kingdom itself. Over 18 months, 7 attempts. They were all stopped. There could be another tomorrow. I'm not making a prediction that you can keep up that kind of success rate. But the key to it was the analysis of bulk communication data. Who called whom, when, and where. End-to-end encryption is spreading very rapidly. It makes the job of getting at content, in many cases, near impossible. As long as the authorities have communication data, there is some chance that they can uncover the kind of threats which we're talking about. Whilst I've got the floor, a quick comment, if you will allow a Brit to comment on your Supreme Court's judgment in Riley versus California. I didn't read this as saying reconceptualize in the cyber era. I read this as a very wise group of judges saying you have to apply brain power when you interpret the Fourth Amendment. You're not allowed to have unreasonable searches and seizures. So a rule that says whenever you see some bit of equipment or laptop, you can just do whatever you like to it, that's not reasonable. But they weren't saying that there are going to be cases in which when the law enforcement seizes the terrorist suspect and seizes all their devices, you aren't going to want and be perfectly justified in going through it all, because that could save lives. So I think the court is essentially reminding us that you can't just have a rule that says, you've seized these devices, you have to be able to justify on proportionality and necessity grounds that you've got a sufficient reason that makes it a reasonable search to go through it all. I'm very comfortable with that.
Thank you. Well, let's collect a few comments from the audience and then give our panel an opportunity to respond. Yes?
Yeah, the issue of regulation of the internet sounds as complex as climate change, okay? And the internet is, after all, a tool, but we talk about it as if it was God, submerging all issues in our lives and everything. And clearly, the internet makes us vulnerable. We make a choice to participate in that way of life. So the issue of Amazon or security, you care about your security, but what about the way of life that we've chosen? So my question stems from the fact that individuals in our society have understood that, and they have devised ways to deal with the internet. I cannot count the number of emails I have. I may be able to count the number of passwords I have. So now I'm going to be using different devices for different issues. I'm not going to connect everything for everything. So my question is, shouldn't we be aware that this is a vulnerable tool, that one that can crumble as a house of cards in some conjuncture, and devise policies to deal with it as a vulnerable tool, as it is wonderful?
Let's take another comment from the gentleman at the table and give folks an opportunity to respond after that.
Thank you very much for a very interesting panel. Sir David Omand was kind enough to provide us with a list of issues he has considered, and I'm glad to say I find myself in agreement with much of what he has put down. I don't think it would come as a surprise to him, however, given my public statements on the matter, that there are a couple of things with which I do disagree, and I'd like to refer to them. Firstly, I suspect the statement which he says, accept the necessity for digital intelligence activity, including, when necessary, access to the internet in bulk as a legitimate means of gathering foreign intelligence and managing the risks of hostile cyber attacks. I'd like to reiterate the advice I gave when I recently presented my report to the United Nations Human Rights Council on the 9th of March, that European courts, and most recently the European Court of Human Rights in Zakharov versus Russia on the 4th of December, and on previous occasion, the European Court of Justice, have actually pointed out that such bulk processing is actually, would actually run counter to the European standards on human rights, and specifically on the right to privacy. Sir David invited us to look at the UK as a model. I'm publicly on record as discouraging the entire planet and hopefully the entire galaxy from looking at the UK as a model, because the law which has been put in Parliament, while notably introducing a number of improvements to the UK position, including that of oversight, with which I find myself often in agreement with Sir David. But it does not, however, successfully close all the loopholes in a way which I would call proportionate. There is much else to be said, but I don't wish to hog the floor. I did wish, however, to relate to the references to Riley versus California. And I think that that is a particularly important case, not so much for the conclusion, which is the requirement for a warrant each and every time a phone is seized, but actually as an indicator that we need to rethink things even further. And this is where I would agree with what we have in Riley, and my famous quote from that is actually another one, which is that and if you'll permit me to give that, is a broad array of private information never found in a home in any form unless the phone is there, right? And what I'm trying to say is that, and this is where I would also disagree with the statement made by President Omand on the 12th of March, when he said, when he implied, I should say, that the procedure that has been existing in the United States for search and seizure for 200 or 300 years is sufficient. It's not, because the phone presents a completely different dimension. And I'd end my comments by reminding everybody that we have, for the past 100 years and more, in a number of countries, had a standard of decency which says you are allowed to remain silent and not to incriminate yourself. You are not even, in the case of a married person, your spouse is not even a compellable witness. Is this to say that the phone is going to be a compellable witness if there's a warrant? And what I'm saying is that in the case of most spouses I know, the phone knows much more than the spouse. Which is why I'd like to suggest that we might think about a situation where not even the phone can be searched with any kind of warrant. Thank you.
Thank you very much. I'd like to give each of the panelists an opportunity to answer either of those questions or make a closing statement that combines them, and I want to toss out one more closing question that you might consider that's related to these two. I recently heard one of the developers of public key cryptography, make the following statement: "A democracy that does not provide the possibility of private communications between citizens is unimaginable." So I would like to have your comment on that, and whether in the coming 10 years we'll have the possibility for private communications between citizens, and if not, what does that mean for our society? So, Sir David, if I may start with you with your closing comments.
Yes, the first point I would like to register is a complete rejection of the United Nations view that it is not possible to have bulk access for legitimate purposes, which we would all, I think, agree are legitimate purposes, conducted in ways which are both necessary and proportionate. Not easy to do this, and I think the warning, if you like, that this is going to have to be executed in ways that where the algorithms that are deployed do sufficiently discriminate between the legitimate suspects and the innocent. The fact is the British courts have examined the practice of my old agency, GCHQ, in huge detail and have found it compatible with the European Convention on Human Rights, precisely because they examined in great detail the way in which filtering, selection was used. This is not the same as mass surveillance. And ignorance on that point, I think, has seriously muddied the debate. The point about choice is an interesting one. My opening remark really said we're past the point of choice. You can't live in this world as a full citizen without living in the digital world. You haven't really got much of a choice to opt out, and therefore full participation in society and its social as well as its economic life means you're in there. You've got to use this. So we've got to do something to enable that to be done safely, which brings me to Laura's point that I've not yet been persuaded that cyberspace is a different realm from the normal 3 dimensions. And therefore, the principle which we have always upheld of that law enforcement can seek evidence should be upheld. In other words, there is no absolute right to privacy in cyberspace. And therefore, yes, it is possible to have private communications, but subject to the 4th Amendment. So there must be the capacity for reasonable searches and seizures. In that sense, the founding fathers made it clear that there is no absolute right to privacy. It's a qualified right. And the same is true of the United Nations Declaration. The same is true of the European Convention on Human Rights. It's a qualified right, and the qualifications are very clearly stated. And we must make sure our systems uphold those. The law must uphold those. I repeat what I said initially. I do think that placing all of these digital intelligence activities under the rule of law, including hacking and the mining of bulk databases, communication data, and the content of communication, that's what the UK is doing. As far as I know, it's the only country on the planet that is really doing that with these kinds of safeguards. I think it's not perfect, but I think in terms of the direction of travel in which I'd like to see fellow European countries move, that's where I'd like to see them go.
Thank you. Closing thoughts, Alan.
Sure. So I will hit all 3 points also in response to what Sir David said. I agree that the physical and the digital share similarities such that we shouldn't change the baseline. And I don't think that anyone's arguing for an absolute protection. But even in the physical space, people have traditionally been able to have private conversations that aren't recorded, that aren't accessible to law enforcement. People can take personal notes, people can write correspondence and then shred them or burn them. So not all evidence is preserved in the physical world, and I think the same thing should not be, we should not unreasonably expect that in the digital world necessarily all evidence will be preserved and accessible. I do think that the scale and scope of digital records does call for greater protections in certain circumstances than would physical analogs, like in the Riley decision. On the point of self-help, I will quickly point to a different quote in the Riley decision that I personally like that points out that in that context, in the context of seizing a cell phone, the users often don't know whether the information that they're seeing on their phone is stored in the device, whether it's in the cloud, and it actually doesn't make any difference to them. And this was one of the points that my organization had raised in our brief in that case, that to say that by placing an individual under arrest and searching the items on their person, that all of a sudden then you can go and access data that's actually in the cloud doesn't actually make conceptually any sense at all. And that's again highlights the difference between the physical and the digital. I think, and the other thing to keep in mind on this point is that, yes, those of us in this room may be very cognizant of the vulnerabilities that we face by using computers and phones and cloud services, but not everyone is. And I think that there is a risk of a severe divide between the haves and have-nots, both in terms of economics and in terms of just sort of world know-how, that those individuals that are in the most vulnerable positions are then going to be subject to the most severe intrusions if we set a standard where, buyer beware, user beware. I think that we have to set a standard based on the rights we've established in the Fourth Amendment and elsewhere, and not simply say that individuals just waiving those rights by participation in society and engagement with technology. And I think this also gets back to the last point, which is that we do need to preserve the ability of individuals to have those private communications. Again, set that baseline that was already set in the physical space, not go below it as a result of changes in technologies.
Thank you very much. And last word from Steve Bellovin.
You can't turn the clock back on complexity. We live in an incredibly complex society. In order to do things with acceptable, not just economic, but human efficiency, we have to accept complexity. And it's an interconnection. It's not just one decision. It's the sum of all of the decisions. Your comment about why do we connect vulnerable things to the internet, the answer is because we either have no choice because we don't know that we're doing so. I mean, once upon a time, if a corporation wanted to talk to a branch office, it would get a leased line. Well, the phone company's facilities have long been digital and hackable and redirectable. But today, it turns out that a lot of the leased lines you get are actually going over the internet, called pseudo-wire emulation. Your phone calls, even ones you don't think are internet phone calls, are going over the internet. It is the network. 20 years ago, I could say it would soon become the data equivalent of the phone network. That happened sometime in the past. And in fact, the phone network is part of the internet today. Even if you think you haven't interconnected, that computer over there, which you may call a telephone, is actually connected to two other networks, one of which, or two of which, are the internet. So we get all of these complexities, all of these interconnections, and this is what makes things work. And some of the complexity has always been there, but it's been hidden. You think of credit bureaus, all their massive data files as creations of modern life. Over the weekend, I saw a fascinating article about the growth of credit bureaus in early to mid 19th century America, but it's a very manual process, relying on storekeepers and servants and cooks and so on to say, so-and-so does or does not pay his bill. So one quote, Mr. So-and-so has a library of 400 books, but he rarely reads. Okay, well, that's clearly somebody in his household. Again, mid-19th century United States. So we've always had this. We've merely scaled up the efficiency to cope with the complexity of modern life. The Fifth Amendment was intended as a check on, call it violations of physical integrity, torture, or imprisonment. But I've always personally viewed it as at least as much a protection against violation of conscience. That's where the spousal immunity comes from. It violates your personal conscience to have to testify against a spouse. I don't see a cell phone as being in that category. I think, to quote Riley yet again, the closing lines, get a warrant, is quite appropriate. Warrants have to be based on probable cause, that you really find something. It's not just a fishing expedition. That's what bothers me about the bulk surveillance, is that it is a fishing expedition without probable cause. And there's a deep question that society and especially law enforcement are going to have to confront head on in the not very distant future about the distinction or lack of distinction between an algorithmic search of data and a human search. And at one point saying, well, the computer is collecting it but not looking at it, just selecting. At one point that made sense. But algorithms keep getting better. And the distinction between human judgment and algorithmic judgment is getting smaller. Algorithms are often finding things that humans have not found. We're going to have to understand what that line is. I don't even have a good mental model. You know, intelligence operations are not going to go away. I'm on record as saying that spying will end sometime after a sustained outbreak of world peace. I do not expect to live even vaguely long enough for that to happen. It's gotten better. Been not a whole lot of conflict in the European continent in the last 70 years, and that was quite unthinkable 70 years ago, given the history of the continent. But the world conflict doesn't seem to have ended, even with the Cold War, quote, ending, unquote, 25 years ago. We need to understand where we draw these lines and how, and we need better mental models for human versus machine intelligence, or what does privacy mean in this world anymore? I don't know. I've heard it said that privacy is the creation of the modern world. Definition of a small town is you don't have to use the turn signal on your car because everyone knows where you're going. You don't have to go back very far in human history when people didn't ever travel very many kilometers from where they were born. And the people you knew at birth were basically the people you're going to know your entire life. We had cities, we had travel, we suddenly had anonymity, and now the machines are taking that away. Maybe that's returning to the norm. I don't know. We need a new conceptual model of this before we know how to implement this technically or legally.
Thank you very much. And it's also important to remember that some of the people who were swept up in the Target data breaches and financial services breaches were never on the internet. They may not even be internet users, just adding to what you said. I would like to thank this panel very much for a wonderful discussion. If you could join me in thanking them. And we will be taking a 10-minute coffee break and then reconvening for the next panel.